Hello, everybody, and good morning. So we're going to wait for a bunch of people to jump in here, and then we will get going. We have a new document that was just filed in the Bryan Kohberger case from the defense regarding his alibi, and it's interesting. So a few things in this that we're going to have a little chit-chat about. Good morning, Lisa, and good morning, Shy. Oh, well, thank you, Shy. Hello, Charlotte. Good morning, everybody. Please smash that like button on your way in. It lets everybody know that we're live. It gets us out there, and we can get started a lot quicker. So, let me just make sure I got all these papers up here. I've also got another thing on Lori Vallow I'll touch a little bit on at the end when we are done going over the Bryan Kohberger thing. Babs, veterans are failing. Good morning. To see you do. Good morning, everybody coming in. Please smash that like button. Only 8 likes on the video. Let's go, people. It is free to do. You can go out and you can smash that like when you come back in. Make sure you got live chat selected at the top of your chat screen so you don't miss anything. So the Bryan Kohberger thing is heating up. The defense does not want to give anything. Thank you, everybody, going out and smashing that like. Thank you. Jean P., good morning. Bonnie Baker. Let's get some of these up on screen. There's Shy and Lisa and Charlotte, Babs, Dacia, Jean P., Bonnie Baker. Get. Nice to see you, Get. It seems that Bryan Kohberger's lawyers do not want to give any disclosure at all. They don't want to show them any part of their hands, even if it is required by law. And that's what makes this filing yesterday very interesting. Good morning, Marie. I hope everything is going good with you, my dear. Sandra, good morning. Smash that like button, you guys, on the way in. Then we can get going on this as soon as we get a bunch in here. Gets us out in the algorithm, lets people know. A lot of people aren't being made aware of the lives when it goes live. So when you guys smash that like button, it does help get it out there and get people notified. Okay. So let's go over here. Present, share screen. Let's get this up. What is going on? Here we go. Oh my gosh, you had heat stroke? Oh my gosh. Take care with that, especially with the heat, you guys. Jean P., good to see you too. Kate Bell. Oh, you got yours? Good, good, good. You're very welcome. Glad that you got it, Kate. I will be sending out more on Monday after Sunday's live because whoever wins on Sunday. Also, you guys, if you get a live read on Sunday, you are automatically entered into the draw for that day. I show it before the live start with the mini reads. So it doesn't cost you anything more or anything less. It's you get a mini read and you're automatically on the wheel to win whatever prize it is for that day. I also have, let me just bring this up while we're waiting. So I'm glad you got yours, Kate. Now, I also have one during the week. So anytime I go live during the week, Anybody that gives a super chat of $10 or more is entered into a draw for a very lovely gift. I'll show you what the gift is for this week. I've already got quite a few entries on it, I think. I got to go through now. If you miss a live, you can always go like to this video once it's posted on YouTube, and you can use the super thanks button that's there. It's a little heart that's just below the video. On any of the lives, any of the videos that I put up this week, you can also enter that way. Hello, Journey's Angel. So this week, let me show you. I'll take my camera. So here is this week's. This is the rose quartz set. This is the necklace, and it's on a gold chain. You can see the chain underneath. I put it underneath so it didn't get all tangled up. There's a pendulum, and there's also this beautiful gold tone bracelet with the rose gold quartz, the rose quartz. So this is the necklace. This is the pendulum. And it's falling all over the place in the box. I'm trying to get out. It's so dark here, you guys. We have been having major storms. So this is the pendulum. It's got the little rose quartz on the end of the pendulum too. And this is the bracelet. So I will be making the draw for this on Saturday. So anybody that gives a $10 super chat during any of the lives or in the description, when you make a comment, you can use the super thanks. You're entered into the wheel live draw. I enter all the names on Saturday. And we do the draw live so you can see the draw being done. So I just wanted to put that out there. No, these I got. I'm supporting local business just down the street from me. There's a shop that opened that sells all kinds of stuff like this and the crystals and everything. I love this. This is the little tree of life. This is the rose gold too. So, oh my God, some dust on that. All kinds of stuff that she sells down there. My mom actually got me this from down there. She has decks of cards, all kinds of the smaller and the larger, all kinds of differences. This is the black obsidian, clear crystal quartz, amethyst, rose quartz, black obsidian. So if you do want to enter for this set, and it's valued over $60, and I generally usually throw something else in with it too. If you want to enter to win this one, any super chats, $10 or more. So if you give a $20 super chat, you get 2 entries. So that's how I'm trying to do it, for giving back, for you guys doing the super chats and that. I'm giving back. So Marie Barks, you are on to, let me get you written down. Marie Barks has got an entry. So when I write down August 4th video, so I know when you entered. So I go through all the comments underneath of any lives from Monday. So Monday would have been the 31st. So from July 31st, right up until the time of the draw on Saturday, August 5th at 11, I think it's 11 or 11:30 a.m. I will do the live draw. No, she doesn't have a website. She just started up, but I'm sure she will get one. K.A. Pisces says, I would love a reading from you one day. I've been following you since you did a reading on the missing Lauren Dumoulin. Yes, every Sunday morning at 11:30 a.m. Eastern, K.A., I do live mini reads. So 11:30 a.m. Eastern every Sunday morning. And I usually go till about 1, 2 o'clock in the afternoon. So if you do want a live mini read, it's done right on screen like we're doing this live here. I do your cards right in front of you. So if you want, that's something you might want to take advantage of. And that's every Sunday morning, 11:30 a.m. Eastern. For validation. No, she just started up. She just opened not long ago. So I'm trying to support her, and I have. I think I blew like $600 in there, and I bought a lot of stuff like this. She did get me some really nice bags. I showed them on the last live. I've got bubble wrap and everything. I bought some decks of cards. that I'm going to be giving away also. I just went nuts in there, and I'm just a sucker for stuff like that. So, okay, so let's get going on this, you guys. Let me get my other screen up so I can see. If you guys do enter, give us $10 super chat or more, I will see it because it comes up on this screen here. So I won't be able to see your comments, you guys, until I'm done going through this. But there's a lot of things in this, you guys, that I want to discuss because, like I said, I believe that the defense is really trying to not give disclosure in the way that it is intended to flow between prosecution and defense and prosecution. They are quick to say the prosecution isn't giving them what they're requesting, but they're doing now the same thing. Okay, so the prosecution has got a hearing coming up to make the public defender give the information that they are looking for. But in this, again, there's a little bit of information that they give out here. So let's go through this. This is the defense's objection to the state's motion to compel, motive of defense of alibi, or alternatively to bar certain evidence. Hey, someone has two. I've been away from home for a few days and came back. Came back to find the St. Michael necklace that I want. It's beautiful, and thank you. You are very, very welcome. So I'm glad, Kate, and someone has too, Laura. I'm glad you guys got the prizes that you guys won. Happy to hear that. And I hope you do love them. Summer Dawn is at work, but listening. Okay, so let's get going. So comes now Bryan C. Kohberger by and through his attorney of record, Ann C. Taylor, public defender, and hereby and objects to the state's motion to compel, motive of defense of alibi, or alternatively to bar certain evidence. Idaho Code 19519 and ICR 12.1 require an alibi disclosure of a specific location with a specific location and witness to so testify. By statutory definition, Mr. Kohberger may remain silent yet testify. So he's trying to keep his right to remain silent, but now he's going to say this. He's going to say he's going to remain silent, which means we're not giving you our alibi. Yet he's going to testify right now saying he was not at 1122 King Road on November 13th, 2022. However, in an abundance of caution and recognizing the court has authority to exclude witnesses, Mr. Kohberger has indicated he anticipates corroborating witnesses. So, what does that mean? He's saying that either he's going to call corroborating witnesses to testify that he was not at 1122 King Road on November 13th, or he's going to use, as he stated in the last filing, that he's going to use the prosecution witnesses against them. So he's going to use them as his witnesses to prove that he wasn't there. Hello, positive vibes. So let's continue. When determining whether to exclude evidence due to late disclosure or non-disclosure, the trial court must weigh the prejudice to the state against the defendant's right to a fair trial. Right. That's why there's a non-dissemination order. Everything is under seal, gagged, everything. So he gets a fair trial. But that does not mean that you don't have to give disclosure to the prosecution. Right? Oh, Nana. Go do what you got to do, my hon. Hello, Dawn. So this piece right here, when determining whether to exclude evidence due to late disclosure or non-disclosure, the trial court must weigh the prejudice to the state against the defendant's right to a fair trial. Well, no. There's Brady rules, there's disclosure rules for a reason. You guys have been claiming foul and crying and screaming from the rooftops that the prosecution's not giving you things that you're entitled to, but You don't want to give the prosecution things that they're entitled to. And one of them is, as soon as you said you had an alibi, that's it. You gotta produce that. Journey's Angel, you have now an entry for the rose gold set. Willow's mini reads are better than full reads you'd get elsewhere. My mini read is still resonating in my heart several weeks later. Let me just see this. Aww. Thank you. Thank you, Journey's Angel. Tenali, good morning. Okay, so like I said, Journey's Angel, you are now entered into the draw for the rose gold set. I will show it again in a little bit. Hello, Shivani. So, it is error for a trial court to exclude a witness based solely on late disclosure without analyzing whether the state would suffer prejudice from the late disclosure. So what are they talking about with late disclosure? Well, the prosecution filed a motion to compel them to give up their witness and where he was at that time that he's claiming he wasn't there, to claim where he was, show where he was, prove where he was, witness names, everything about the alibi. They have to disclose that now. Now, the defense turned around and said, well, we're not disclosing that. We may or may not be using your own witnesses against you. He may or may not call his own witnesses. And the prosecution saying, no, we're not waiting to get ambushed during the trial. We are entitled to that disclosure, and we want it. Whereas the defense is saying, well, you'll find out about it during the trial when you put a witness on that we may use to corroborate where he was. You can't do that. Okay? So what the defense is doing now is playing dirty a little bit here, because they are getting the public in an uproar saying the prosecution isn't giving us the evidence that we deserve for disclosure, but now they're trying to do the same thing to the prosecution. You can't have it both ways. You got to follow the rules of disclosure. So now they're saying that they should be able to disclose this late, which means during the trial, when the prosecution puts a witness on, we're going to pounce on it then. And they don't want to be penalized for that. Okay. Well, if you don't want to produce the evidence regarding, and there's strict rules regarding alibi, you have to produce it to the prosecution, like the prosecution has to produce to you. So they're crying foul, and they got, as far as I'm concerned, the judge is going to be denying all of this. But it gets better. In addition to weighing the competing interests at stake, the trial court should consider whether less severe remedies would be sufficient for the untimely disclosure or non-disclosure, such as a short continuance. So they've already got a 37-day continuance to go over the grand jury reports. Now they want another continuance. So they're trying to get extra time without losing his right to a speedy trial. It's one or the other. You are the one that is saying you're ready to go. You're not waiving your right to a speedy trial. 6 months, the prosecution, you better be ready because we're going, we want speedy trial. But now you're asking for these continuances. And this is what the prosecution was worried about when the judge gave the first continuance. Your Honor, we see this going to be coming a thing that they continue to do, so they keep their right to that speedy trial. You either waive it or you don't. You did not waive your right to a speedy trial, so you can't keep asking for these continuances for stuff that you want, that you've been given, but you want more time to go over it, and not disclosing things that you already have. Hey, sister. Hey, Charlotte. Me too. There's sister. Okay, so in addition to weighing the competing interests at stake, the trial court should consider whether less severe remedies would be sufficient for the untimely disclosure or non-disclosure, such as a short continuance, a mistrial, or sanctions against defense counsel before excluding a defense witness. Well, that's exactly this right here is what they want. So are they, holding back disclosing this information to try and get a mistrial or a short continuance? This is what they're trying to push for. They've been asking for a mistrial already. They want everything thrown out. They want to throw out all the grand jury information, which I don't think is going to happen at all. I think the indictment's going to stay. They want a preliminary hearing because they want to see more of the evidence and be able to cross-examine to see what they can grasp at. They don't have that right now. The prosecution turned over the transcripts of the grand jury. That's what they said they wanted. They got it, and now that's not good enough because now they want to throw it out because they didn't get the chance to cross-examine the witnesses that came forth in the grand jury. Well, that's why a grand jury is called. You know what I mean? So it's like they're not saying that the prosecution did anything wrong. What they're complaining about is now they want to cross-examine them witnesses. Well, you'll get a chance to do that at trial. You can't hold back disclosure because you didn't get a chance to cross-examine witnesses at a grand jury hearing. That's not the way a grand jury hearing works. So they're playing with the court system here, and I think the judge is going to get a little upset about this. The trial court has an obligation to fashion a sanction which will impress counsel with the importance of responding to discovery requests, and yet will not prejudice the defense of the case. So it's like, we want you to give us what we want. And you've got to be careful and impress counsel with the importance of responding to discovery requests. Well, give the discovery requests that are being asked of you. They want every rule to be followed to the T, or they're filing motions. And what they're trying to do right now, you guys, if you want my honest opinion, is they're trying to bury the prosecution in motions so they don't have time to get this case to its best possible place for this October 2nd trial. If you're throwing all these motions and they constantly got to be in court defending themselves and requesting disclosure from the defense and everything else, they're not getting their case to the best possible presentation that they could get it to because they're too busy dealing with all this crap that's going on in motions and everything. That's what I think they're doing. Okay? My opinion only. Well, you know what? Positive vibes. I'm glad you brought that up because you know what? I see so many people out there and channels that are defending Bryan Kohberger. Oh, well, I heard this and I heard that. And somebody from there told us this and somebody from there told us that. Yet when we go over the facts right now are what are in that probable cause affidavit. That's the only stuff that can be relied on is the court documents. That's the only fact that is verifiable that is out there right now. We are basing our opinions on what is in that probable cause affidavit, the GPS, everything there. That's what we talk about, okay? So then you get these people, oh, well, he didn't do it. They didn't say this in there and they didn't say that. They don't have to say everything. They don't have to give all their evidence in the probable cause. They have to give enough to get him arrested, okay, and brought to trial. That's what they have to give. So if you think that that's all they've gotten there, it's not. So with that being said, because people like myself talk only about the verified information, which is court documents and what is actually can be proven and verified in court documents, they're saying, oh, you're just going by theories and this and that you're making up. No, I'm going by the court documents and what they say. What they're doing is they're talking amongst themselves, people that are all over the world, coming up with theories and this and that, and reading things into what they're reading and trying to make sense of it by making up other stuff, fake videos that have been put out of the scene that night, and fake screams and fake this and fake that. So much fake stuff going on out there. And they're coming up with their own ideas and theories about what happened. And it wasn't Bryan. He was over here at McDonald's and he was here and they've got a witness. And what are you guys basing your opinion on? On rumor, on made up stuff, on fake news that has been already debunked. That's what you guys are doing, not us. So when they say, well, he is not guilty because so-and-so that used to go to school with him and blah, blah, blah said this. That's not fact. So they're basing his innocence on rumor and speculation that they're hearing from God knows who. Surely is not from the affidavit. It is not from anything that's verified through anything, court documents or anything like that. So that's what irritates me. Yes, Vera Ray. I'm going by the GPS of the car, the pings, where he was. I'm going by what is in the affidavit. Okay? I'm going by other court documents that have come out from the defense and prosecution that give us a little bit more info, by searches that were done, by search warrants and stuff like that. I'm going by everything that is verified that's in the court record. I don't, oh, so-and-so said that, the day before this and the day after that, he's seen Bryan and his car was good. No, I'm not going by that, because anybody can say, I can sit here and tell you right now, you know what? I seen Bryan Kohberger at 10 after 4 in the morning. He was sitting out on the top of a hill in the middle of nowhere. I was out there fishing out in the middle of nowhere at this little pond, and I seen Bryan Kohberger there that night. Does that make that a fact? You got to prove it. It's got to be corroborated. So say I'm his alibi. Yeah, man, I was out by Genesee in Idaho there in Genesee fishing at this little pond, and I seen him. He was sitting there looking at the pond on the other side on the top of the hill over there, and I seen him, and he was just sitting there gazing at the stars. He got there at about 3:45 in the morning and didn't leave till 6 a.m. I could say that. Does it make it true? No. What the police would do with that is now they're going to investigate me. They're going to look at my GPS. They're going to look at my phone pings. They're going to look at everything me to corroborate that I was there, or if I was even there. You know what I mean? So that's why they have to give up their disclosure. Anybody can say anything. Okay, so let's get back to this, because she does say some stuff here, okay? They are trying to peeve off the judge enough that the judge does a mistrial. I don't know. I don't know what they're trying to do, but it's getting irritating. However, when the defendant's discovery violation was willful and designed to facilitate the presentation of fabricated testimony or to impede the state's ability to conduct effective cross-examination or to present rebuttal evidence, exclusion may be a proper remedy, notwithstanding the availability of other sanctions that would prevent prejudice to the state. So they're saying here that if there's some fabricated testimony, well, there's sanctions or whatever that the judge can do to make sure it doesn't impede the state's ability to conduct effective cross-examination. Well, if you got a witness saying that he's not there and you're going with that, you better produce it so the state can cross-examine, but you can't spring it on them. Mr. Kohberger has had, okay, here we go. Listen to this, you guys. Mr. Kohberger has had a habit of going for drives alone. Okay, so this right here. So, do they have a witness, which is fine, that's going to come in and say, hey, look it, I've known Bryan Kohberger since, we're 16 years old, and he's always done this. He's always gone out and drove around at night. Okay? To me, how can I say this? This strikes a red flag for me, and I'm going to tell you why. They are basically, you just threw your client a little bit under the bus, because you are stating that Mr. Kohberger has had a habit of going for drives alone. Often he would go for drives at night. So you are admitting that Bryan Kohberger likes to go out late hours of the night and drive alone. So why would you get up, and leave at 2 something in the morning and drive to the area of 1102 King Street, and where the murders happened, and be in that area and be seen in that area, and trying to get into their driveway and doing a 3-point turn, going back and forth in that specific area, and be in that specific area for an amount of time that we don't know what you were doing, but that is the time between 4:05 and 4:20 that they believe the murders happened, and you were in that area. Your car was seen going in, but not caught on video camera, like driving around for a bit, trying to, how do I get out of here? Where am I going? Blah, blah, blah. No, you're off camera from any of the cameras that captured your car that night at that address for 20 minutes. And then your car is caught speeding away. You had been just casually driving back and forth and turning around and almost trying to get into their driveway, but then going up and doing a 3-point turn, and you're driving properly. But then by the time the murders had happened, when they were done, you're speeding away and you take the long way back home. So, Mr. Kohberger, you're also seen creeping out that area 12 times late at night. To me, I'm thinking you're either a stalker, a creeper, a peeping Tom, something, to be going out driving alone at night into areas. And it's not like, I'm going to go to Walmart. There's nothing that gives him a reason to be in that area unless he knows somebody there. There's not like a corner store or a gas station within a couple blocks of that King Road house. There's not a Walmart. There's nothing there that would be like, well, I went there because my dentist is there, or my doctor is there, or the Walmart's there. No. Unless you specifically know somebody that lives there, you would have no reason to be in that area. And it just happens, Mr. Kohberger, that you chose that area 12 times to just drive around at late at night until the early morning hours of the next day. And that just happens to be where these 4 college students lost their life at the exact time that you're there. I could go on and on. So this, to me, I would jump all over this if I was a prosecuting attorney. He would go for drives at night. Look at this. She puts him there. He did so late on November 12th and into November 13th. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to precisely, I think, to say precisely where Mr. Kohberger was at each moment of the hours between the late night of November 12th and early morning of November 13th. So do you get that? He's not saying, you know what? I drove on the highway there, where you would have turned right to go down towards the King Roadhouse. I went by there, but I went to the gas station. I went to Walmart. He can't even say where he went. And if you were just going for a drive like you usually do and drive around the town, whatever, why didn't you do that in Washington? Why'd you come to Idaho to do it? And why that area? And then why, once the murders were committed, did you take the long drive home out into the countryside? If you wanted to just go for a drive at night to get away from the city bustle and hustle or whatever, why didn't you go the other way through Pullman and go down into the countryside there instead of going all the way into Idaho, be in the area of 1122 King Road? The murders happen, and then you hightail it out of there and then go way out into the countryside with your phone off while you're in that area of the house. On your way to the King Road house, you turn off your cell phone. It comes back on as you're heading out. You're already heading out of Moscow, and you're near Genesee in the other little town there, and that's where you turn your phone back on. Why would you even turn your phone off if you were just going for a leisurely drive that you always do? Why this night did you turn off your phone? Why? Okay. So now his lawyers have put him out driving around at that time of the night when the murders happened. Why did you turn off your phone? If this is something you always did, was go out and drive around for whatever reason at early morning, nothing good happens after midnight, 1 o'clock in the morning. If you're out by yourself just driving around, you're either a stalker, a peeping Tom, or you're looking to do something criminal. Unless you got a baby in the back seat, that's the only way you can get them to go to sleep. You got no reason to be out just driving around and scoping out people's places. And the 12 times in that area, and you don't know anybody in that area, you don't have a reason to be in that area. There is no reason that would bring him there. Like a Chick-fil-A, that's the only Chick-fil-A. It's right there by King Road address. No, there's nothing there other than if he knows somebody. There's no reason that somebody, especially somebody who's from Pennsylvania, going to school in Washington, would pick that area to be in 12 times and then be there again the time of the murder. And then speed away from there and then go the long way home. You see what I mean? And why would you turn off your phone if you're just out casually driving around for whatever reason? You're turning off your phone so you can't be tracked by GPS on your phone because you're doing something criminal. That's the only reason you'd want your phone off. That's the only reason somebody would look into your GPS data for that night, is if you did something criminal and you were caught for it or you were being accused of it. Like, there's nobody sitting in the police department going, oh, look at that. Mr. Kohberger went for a drive last night. Let's check his GPS. You know what I mean? Let's check his phone pings because he was out driving around. If you hadn't done something wrong or you're not accused of doing something wrong, your GPS and your phone data would never be looked at. So why did you feel the need to turn it off just before you get going towards Idaho, and then turn it back on when you're 5 minutes outside of Idaho, where the murders happen? Okay. See, as an investigator, and I did a lot of private investigation work and working in the criminal justice system for 30 years, I see this stuff. To me, I would be peeved right off right now for Ann Taylor putting something like this out there. So Mr. Kohberger has had a habit. So I wonder if he's done other things. Wonder if he's been doing other things that he shouldn't have been doing, like peeping Tom and stalking and stuff like that to others. Because it says he has a long habit. Long habit. Well, guess what? Guess what the prosecution's going to do now? Now they're going to start looking into his habits. Often he'd go for drives at night. Yeah, when people are generally in their homes sleeping and not seeing what he's doing out there. He did so late on November 12th. She's putting him out. She's putting him out there. Mr. Kohberger's not claiming to be at a specific location. Why can't you are being accused of a heinous crime? Wouldn't you remember where you were and what you were doing? Hey, whoa. Wait a minute here. I got an alibi and this is where I was. Blah, 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 blah. Here, check my phone. Oh, we can't because you turned it off. I think she's kind of, my only opinion is she threw him under the bus. And I don't think that's what she was intending to do. Crime Traveler just happened to leave his DNA, and that's coming. I'm just talking right now about alibi. There's so much other stuff that puts him there. And now she puts him out driving. Okay, he's admitting he was out. And you know why she's doing this now? Because she went over the grand jury transcript. She's going over them. And she's seeing certain things that she didn't know before. Right? That was done at the grand jury. So now, this is why they wanted that grand jury transcript. They wanted to see what they had and what they could prove. So now she knows she's got to come up with something because they know he was out and they can prove it. So this is why they've come up with this. And I think we're going to see a lot of this, you guys, as she goes through that grand jury transcript. Yeah, harvesting potatoes at 3 a.m. So if I'm being accused of this, I would be telling you exactly where I was. Look at, I drove down this highway. I was here. I was there. I was here. I was there. I was somewhere out that way. You would at least remember parts of where you were. He's not claiming to be at a specific location at a specific time. Because if he did tell you that, it's going to incriminate him even more. Because we know where he was. We know by his phone and we know by his GPS on the car. And we know, or not GPS on the car, but the video that we got of his car. There's not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night, November 12th, and early morning, November 13th. He was out driving during the late night and early morning hours of November 12th to 13th. You just put him up. So now he can't say, look, that was not my car. So how are they going to use this now? Well, thank you, Ann Taylor, for telling us that he was out and he was driving. Now he's admitted to it. And we've got a car, his type of car with no front license plate, which kind of narrows down an Elantra with no front license plate because Pennsylvania, which the car was registered, didn't require a front license plate. But Bryan Kohberger thought he was smart. What he did is on the 18th, after these murders were committed, he went and got Washington state plates. Why are you getting Washington state plates when you're going back to Pennsylvania? Because now, if they did have his car, well, look at, my car has 2 plates. That's not my car. That car there has no front license plate. Like, does he really think that people are that stupid that we wouldn't look into that? But she's putting them out and driving now. So now we know the GPS that they've got and the cameras that they've got of him are correct. Because now she's saying, yes, he was out driving. They're not going to say where he was driving because, what, he can't recall? I don't know. They didn't say that, but they said that they're not giving a specific place, location, or specific times. But they are saying that he was out driving around. Counsel for Mr. Kohberger is aware that case law broadens the definition of alibi with the statutory requirement of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. So what he's saying is, we don't know everything that this witness is going to say because we only see what he said. Okay, so there's a specific witness. This is what I'm thinking. They're going over testimony of a specific witness during the grand jury indictment, okay? So I think what they are saying here is, okay, this person, we're going to say, Shy, we're going to use you. Shy testified, and the prosecution only asked them certain questions, and they replied with these answers. We think there's more that we can pull out of that testimony, and we think that that person is going to be testifying to a lot more than what they already have at the grand jury. Remember, they don't need to bring everything out. They only need to bring enough out to get the arrest warrant and to show probable cause. So Shy could have said blah, 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 but there's so much more that Shy is going to say come trial. So that's what I think they are jumping on. With what Shy said, the defense is thinking, okay, well, if we ask certain questions of that witness may end up proving to be Bryan's alibi. Because if they answer our questions that we state a certain answer to our questions, that would prove that he was not there. That's what they're trying to do. And they can't give any more information regarding that because they don't know which witness that they've already read their testimony from the grand jury on is going to bring out the information that they think is going to give Bryan an alibi. They just know that one of them might. You can't go like that. You can't do that. You can't go fishing. This is not a fishing. The same as when a search warrant happens. You can't go on a fishing expedition. You have to state what you're looking for and where exactly you think it is in that place. You can't just go, oh, we just want to go and search the house and see if we can find anything. No, you got to have specific things that you're looking for, and with those specific things, you got to let the judge that's going to sign that search warrant know where you think those things are: in his car, in his bedroom, within his personal property, in the garbage, whatever. Hello, Patty Ward. So this is why they're saying he has complied to the extent possible at this time. Yeah, because you don't know what else these witnesses are going to disclose during trial. Corroboration of Bryan Kohberger not being at 1122 King, it should be Road, may be brought out through cross-examination of the state's witnesses. Maybe. If you say you have an alibi, it can't be, well, our alibi might be brought out through cross-examination. No, you got to have evidence that this witness seen him and this is where he's seen him, so at no way could he have been there. You can't say, well, it may or may not come out during cross-examination. You can't do that. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. Well, you're saying that they are going to say he's not there. You just said it here. Cooperation of Bryan Kohberger not being at 1122 King Road. And now you're saying he can't be more specific about the possible witnesses and exactly what they will say. Make up your mind here. Talking in circles. The defense has been hampered by the state's own choices. The state chose a secret grand jury. So this is shots fired. This is shots fired. The defense has been hampered by the state's own choices. No, you haven't. You know how many thousands of cases go through a grand jury indictment instead of a prelim? So they're trying to blame the prosecution for them not having, or them not being able to get evidence of an alibi. If you have an alibi, if your client says they have an alibi, it's up to them to produce it, not up to the state to produce it. This is shots fired. That's a shot at, and the judge is not going to like that. The state chose a secret grand jury rather than the planned preliminary hearing. The state chose a secret grand jury because they didn't want information getting out to the public to put other people at risk. And since they weren't going to waive their right to a speedy trial, they wanted to get this done quickly, get the indictment, get him arraigned. Let's go. There could be other reasons why they chose that way. People could be at risk. If it was during a preliminary hearing that is open to the public, people that are going to be a witness for the prosecution during trial, they don't want anything happening to them. They don't want them threatened, harassed, anything like that, doxxed, anything. So that's why they went that way. Had the state moved forward with the preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. So they're peeved off because they can't cross-examine these witnesses until trial. But you've got a synopsis of what they are going to say at trial, and that's all that has to be given to you. Right? They are peeved that they're not getting a chance to cross-examine these witnesses. And they're not being able to get what they think is going to be his alibi. So, to me, out of the 6 people that were our victims, because I believe Bethany and Dylan are victims also, okay, there's only 2 victims that are alive. And I believe that the one that they want to cross-examine is either Bethany or Dylan. They're the ones they want at. They're the ones they want at. That's what I believe. Instead, the defense has only received on July 27th a copy of the testimony the state chose to elicit. Review of such is underway. The defense had to obtain investigative materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. This is another shot. Because if you remember back, we went through that whole thing and they were saying, we are not blaming the prosecution. The FBI hasn't given these records to even the prosecution yet. So we need the prosecution to get on their butts, which the prosecution was on their butts because the prosecution wants that evidence too. So they're trying more or less to say that the prosecution is trying to stop them from getting this in a timely manner. No, the prosecution doesn't even have it yet. And they are on FBI. Come on, we need these reports. We need these reports because that's part of our case too. So this is another low blow that they just took at the prosecution. But the defense said, we're not blaming or saying that the prosecution is doing any wrongdoing. We understand they're having a hard time getting that evidence too. Right? But now that you see your alibi is not going to fly unless you produce the name and the places where you're saying Bryan Kohberger was, that you're going to lose the alibi defense. Now you're taking low blow shots and trying to put the prosecution in a light that is not favorable to them. And this is why you get all these other, the prosecution's holding all kinds of evidence back and they're not giving it to the defense. Really? Yes, they are. And the defense has even said they're not blaming the prosecution. They're blaming the other agencies not giving that yet to the prosecution. Prosecution is going hard trying to get this stuff. What are they going to do? Hold a gun to an FBI agent's head and say, give me the information? Come on. They're trying their best to get these other agencies to give them the information, and they will promptly turn it over to the defense. Whereas you got the defense trying to withhold giving disclosure intentionally. Because why? Because they got no alibi. They're hoping by some magical little fairy is going to come and through one of the prosecution's witnesses is going to put her magic wand on and say, I was with Bryan Kohberger. I'm going to change my statements. I was with Bryan Kohberger. Come on. Okay, so the defense had to obtain investigative materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. The state made draft disclosures just 2 weeks ago because that's when they got it. That's when they got it. They hadn't had a chance to go through it all yet to see what was what they had to disclose and what they didn't. They got to go through what they get back and disclose what by law they have to disclose. Maybe take out names like blackout names so names aren't say. I don't know. But I do know when the prosecution receives evidence or stuff back from the FBI, they've got to go through it and see what is discoverable. Even if there's exculpatory stuff in there, they have to give that to the defense. And they have, so what they've said is, look at, so far we've got this, and this. This is what this is saying. This is what this is saying. There could be more there. Let us go through it. But this is basically an overview of what is being said in either testing or whatever these things are that they're materials that they're waiting for. They gave them an overview. We're getting it together. We're going to be sending it off to you, but here's the overview of it. We just got it. Right? So she says the sufficiency of these disclosures is currently being analyzed. Well, the state made a draft just 2 weeks ago. Yes, because that's when they received it from the FBI. They can't give you something they don't have. So instead of waiting a couple days after getting it, they said, look it, we've got it. We still got to go through it. Just like you guys want to analyze everything. We've got to analyze this. We've got to go through it, see what is discoverable and what's not. We're going to give it all to you. Everything that's discoverable and everything that you're entitled to, even the exculpatory stuff, everything, you're going to get it. Here's what we've got so far. Here is an overview, and you are going to get the full thing. And like, it gives them something to start with, right? But they can't, they got to go over it themselves. Is the defense going to get some materials back and just hand it over to the prosecution before they get a chance to go through it? Absolutely not. They don't even want to give stuff that they said they've had since the beginning. Right at the beginning, everybody's saying, oh, Bryan Kohberger, he has a right to remain silent. Then he should have shut his mouth right from the beginning and not said, I'm going to be exonerated. I'm going to prove my innocence. I'm going to be exonerated. And then say, I got an alibi. Should have shut his mouth, right? You can't open your mouth and then claim foul when you've opened your mouth. And then when you bring out you got an alibi, well, now you have to produce that. It's discoverable. And people just don't seem to understand that. Okay, just give me a second here, you guys. I'm just checking chat. Okay, Sophia, we don't do that here. Do not attack anybody here. Call them names. We don't do this stuff here. If I see it again, you're going to be blocked. We don't do that here. Everybody's entitled to their opinion. Attack the evidence. Do not attack the person. Okay? I have no problem with people in here believing that Bryan Kohberger is innocent. But when you start attacking another subscriber or a mod in comments like this, good thing you're not on this jury, you're biased, you're attacking the person. If you cannot attack the evidence or the lack of evidence, do not attack the person. Next time, you're gone. So one of the mods, please remove this comment. We don't do that here. Now I forget where I was. I'm very sorry about that, Alley Cat. It's unacceptable, and we don't do that here. Okay. Juror 11. Shy, please remove that comment from her. We don't do that here. Instead, the defense has only received on July 17 a copy of the testimony the state chose to elicit. Well, the judge should say some of it's going to have to be redacted to protect the people who testified. Review of such is underway. The defense had to obtain investigative material. Oh, I already read that. Corroboration of Bryan Kohberger not being at one, and she repeats herself throughout this, you guys. Corroboration of Bryan Kohberger not being at 112 King may be brought out through expert witness presentation. She said that up here too. Up here too, she said it. So she's repeating herself in this. That analysis is underway. The defense has been diligently working to analyze relevant discovery materials and conduct its own investigation. Notably, the defense had to obtain a court order to receive relevant discovery materials. That delay hampers the defense investigation. It's okay, Alley Cat. I would have reacted the same way to somebody calling me biased. That's just like somebody calling somebody racist. Like, don't do that. You don't know me. So, no, I do not allow that in my chat. This is a safe place for everybody. Attack the information. Attack the materials. Do not attack the subscribers, the mods, or myself, or you're gone. So, again, she's bringing up, she's trying to get some sympathy here with how she's wording all this. Had to obtain a court order. Well, the judge knows that because he's the one that, ruled on it. And like I said, the prosecution can't give you what they don't have. They're not withholding anything. They didn't have it yet. And as soon as they had it, they let you know. The right to offer the testimony of witnesses and to compel their attendance, if necessary, is in plain terms the right to present a defense. The right to present the defendant's version of the facts as well as the prosecutions to the jury so it may be decide where the truth lies. Right. The right to present the defendant's version of the facts. Then give it. Give your alibi. It's your right, and actually it's in the disclosure rules. Give it. Nobody's stopping the defendant from saying his version, except for himself. He's asked to remain silent. Just as an accused has a right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has a right to present his own witness to establish a defense. See that highlight? This is like the friggin' Twilight Zone here. I need a sip of my ice. I got this iced tea. It's good. Whoops. He has a right to present his own witness to establish a defense. Nobody, I guarantee you, nobody in the district attorney's office or in the court or in the true crime community, nobody have I ever seen in this case saying, Mr. Kohberger, you don't have a right to present your own witnesses or establish your own defense. You don't have that right. Nobody has ever said that. And the way she's putting things in here, just as an accused has the right to confront the prosecution's witness for the purpose of challenging their testimony, yes, that's what you are there for. And you will be confronting them and their witnesses, and you're entitled to see the grand jury transcripts, and they're telling you who their witnesses are going to be and what they think that these witnesses are going to be saying. The prosecution gave you all that. It's you guys that aren't giving yours to the prosecution. So just like you say, an accused has a right to confront the prosecution's witnesses for the purposes of challenging their testimony. The prosecution also has the right to confront the defense's witness or alibis for the purposes of challenging the testimony and finding the truth. So, what does that mean? Yes, you have the right to cross-examine the prosecution's witness, but they have also the right to have yours, which you don't want to give, but you expect them to give. So, Bryan Kohberger says, I have an alibi. His name is such and such, and this is what he's going to testify to. The prosecution has a right to cross-examine that and ask questions about it. They have a right to investigate that person, and they have a right to then get records of that person's phones and everything to corroborate where that person was with what they are saying. You think we're just going to take somebody's word on it? When we have all this evidence that points to Bryan Kohberger being the guy? You're going to bring a witness. You don't think we're going to investigate that witness and make sure we can prove with corroborating evidence like his cell phone and stuff like that, that where he was? They have a right to do that, just like you just said here. An accused has a right to confront the prosecution witnesses for the purpose of challenging their testimony. The prosecution has the same right with yours, and yours is an alibi. That is in the rules. Yours is an alibi. You have to produce that so they can challenge their testimony and find out if they're lying or not. Why doesn't this lawyer get that? Why don't people get that? This right is a fundamental element of process of law. So is the prosecution being able to investigate your alibi. You can't just pounce that in the middle of trial where the prosecution has no way, no time, no nothing of investigating that to make sure your witness that's going to be on the stand saying that he was with Bryan Kohberger, they have a right to investigate that to make sure this guy isn't lying. So they want the prosecution to follow the laws of evidence and disclosure, but they don't want to follow it. They want to be able to investigate every prosecution witness, but they don't want to give that same to the prosecution to investigate their alibi. It's law. So don't say that it's a fundamental element of due process of law and a right when you are not affording the same thing to the defense or to the prosecution. And whether you want to or not, they have a right to that disclosure. The defense acknowledges a vast amount of discovery has been provided. Discovery is received on nearly weekly basis. Right. Thank you. The defense reviews and acts on the discovery as quickly as possible, including making appropriate supplemental requests for discovery. Well, if you'd read through the discovery first before you start doing all these motions, you may have your answer already in that discovery, and you're wasting the court's time on all these stupid motions. And what they're doing is, like I said, they are bombarding the prosecution with motions so they don't have the time to get their case together, right? If they're too busy trying to answer all these motions here that are going on, they don't have time to get their case together to the best form that it can be. The defense reviews and acts. Okay, so they're saying every week they're getting new stuff. Yes, this is not a simple case. This is a death penalty case. There's constantly going to be information coming in as it's found. You want that because this is not just your client's going to get 30 days in jail. This is the rest of his life or possibly a death sentence. So every time they get something, they are making sure that you get it. And now you're complaining that you're just receiving discovery on a weekly basis. The state's motion is an attempt to force the defense to open its work product files and let the state peek inside. No, they are not. You claim to have an alibi. They want the name and what that person is going to say. You guys claim to have the alibi. You have to produce it or you're going to lose it. And I think the sanction on this should be they lose the right to the alibi because he's grasping at straws. There's no alibi. It already would have been produced. I was with John Blow, and we were here, and here. Or Joe Blow seen me between the hours of 4 a.m. and 4:30 a.m. during that half hour that the murders apparently occurred. I was seen by so-and-so somewhere else. Give it. You don't. You can't because you ain't got it. You're grasping that hopefully something in testimony will come out that you can latch onto and maybe switch around to go in your favor. You can't do that. You can't go on a fishing expedition. You have to give it. You stated you had an alibi. You have to give it. The defense has stated all that it can firmly state at this time. The only thing that the defense has stated is possibly, maybe one of the prosecution witnesses may slip up and say something that we can use as an alibi. This is not trial by ambush from the defense. Oh, yes, it is. The same as you're trying to claim that against prosecution. That's exactly what you're doing. This is defense requesting information as quickly as possible, yet in some incidents face the delay of requesting a court order to obtain information. The state continually uses those opportunities to attempt to force a waiver of a speedy trial. No. You are trying to backdoor and try and get the prosecution to say, okay, look it. I'm tired of all these motions. We got to get our case together. Let's just give it to them. That's what the defense is trying to do. They're trying to break down the prosecution so they get exactly what they want without having to turn over what they by law have to turn over. And exactly what they are accusing here, oh, we're not trying to do an ambush by the defense. If you decide mid-trial that you want to call an alibi or now say we have an alibi witness, that's an ambush. You don't want the prosecution doing it, but you want to be able to do it. You can't have things both ways. The state continually uses these opportunities to attempt to force a waiver. No, as far as from what I'm understanding, like I said, I am in Canada. So I looked into this speedy trial thing. And to me, I know that if with speedy trial, and I know a difference from state to state to state, speedy trial, if the defense causes something to happen during those 90 days, during their speedy trial, if they cause something to be delayed, then that goes against the defense. So what they're trying to do is use an old insert of something or other or this or that with getting these continuances. But in reality, in Idaho law, when you do something like that, you are giving, it's almost like a giving up of your speedy trial right. So if they are asking for another continuance, I think their speedy trial right should be given up. Now, the reason why they're trying to do this and just add time is because they need more time for whatever reason. I don't think you can't just put that all on the prosecution. Prosecution is giving stuff as it's coming in. What they are trying to do is they don't want this automatic waiver now of speedy trial, but they want extra time. When the defense causes something to cause a delay in the speedy trial, they waiver their right to the speedy trial because the judge can either order that the speedy trial right is wavered, or there's other things that the judge can do. But what Bryan Kohberger wants is if he waives his right to a speedy trial, he could sit in jail for 2-3 years before his case is heard. That's why they don't want this waiver of speedy trial. But they want to keep adding time onto it. No, if you are saying you want a speedy trial, you best be ready on your speedy trial date. They're trying to get extra time in there to prepare, because if they're not fully prepared, and I'm not saying, how can I say this? I think there's things that the defense want to do that is not anything being held back by the prosecution. I think there's other things going on there. Maybe trying to convince people to come forward with information or whatever they're trying to do. I don't want to put words in their mouth. And they need extra time for that. But they don't want to waive their speedy trial. So they're trying to throw things back and make it look like this is all the prosecution's fault, so they don't have to waive their right to a speedy trial. We shouldn't be held, to the October 2nd court date or give up our right to a speedy trial, because if we do get this evidence, then we still can go forward good. Like, we don't want to waive our right to a speedy trial and then he'd be held in jail for 2 years until his trial, because then the trial can be held at any time. It gives the prosecution a lot more time to get a lot more together. So that's my thought on that. State's motion is an attempt to force the defense to open its work product files and let the state peek inside. No, they want the alibi that you claim you have. The defense has stated all that it can firmly state at this time. I said my thoughts on that, yeah, because you need to know what these witnesses said, and you're trying to get the grand jury indictment thrown out so you can have a pre-trial preliminary hearing, so you can find this stuff out that you want, that you're really not going to get, because the judge isn't going to throw out the grand jury indictment. And if the judge, you guys, was to throw out the grand jury indictment, they would be right back in that grand jury again. He doesn't get out of jail. He's going to still sit in jail. But I guarantee you within a day or so, another grand jury is going to be formed and they're going to come to another indictment. They're also stating that the grand jury should come to the conclusion the same as a trial jury. No. They only have to go by preponderance of the evidence to come to a conclusion that he probably did this, probable cause. The grand jury doesn't have to find he did it beyond a reasonable doubt. That's for a trial jury. They are never and have never been, I don't care what the 1975 law, 1876 law states. So we have evolved since then, people. Come on. We have evolved. We don't need our feet to push our stone cars around anymore. The laws have evolved since then. And to me, this is a stall tactic. But there is a little thing in there that kind of sort of could say that, depending on how you're looking at it. But it's always been probable cause, preponderance of the evidence, that they believe that he's the one that did this. You're indicted. Whereas a preliminary hearing, the defense is also there and they can cross-examine some of these witnesses. They're not going to get a preliminary hearing. And I think the judge is going to throw this out anyway. So the defense is requesting information as quickly as possible, yet in some instances face the delay of requesting a court order to obtain information. You said back when, before you got some of this grand jury testimony and started going through it and seeing what they actually had, some of the stuff you may not have even known, now you're going, oh shit, now what do we do? You are given the information and materials as the prosecution is getting it. The state continually uses these opportunities to force a waiver of speedy trial. No, you keep using continuances and trying to hold on to that speedy trial. You can't have it both ways. You either want your speedy trial and you want this trial to go forward October 2nd, or you don't. You can't do that. That is a decision left to Mr. Kohberger and Mr. Kohberger alone. Right. And he did not waive his right to a speedy trial. He said he wants a speedy trial. That's what he's getting. Stop delaying it. And you're using tactics and trying to throw it on the backs of the prosecution as to why you have to have these continuances. Mr. Kohberger was out driving alone. Okay, so all these people, and I've had tons of people Bryan didn't do it. He was not by himself. There was other people with him. Maybe it was one of them. He is stating that he was out driving alone. So this happened by him and him alone. He was alone. He did it alone. Corroborating evidence may come from cross-examination of state witnesses. Corroborating evidence may come from the presentation of defense experts. So, this isn't coming from like somebody who maybe seen him. This isn't coming from I've heard, oh my God, the stuff that I've heard. What's the other? There's Bethany and Dylan. Dylan said she was in her room. She's seen this guy with bushy eyebrows describe Bryan Kohberger. Bethany hasn't really said anything. So what happened when this come out? I don't think people read through documents and really go over and understand what these documents are saying. Now the rumor going around, and here's another rumor to watch out for, you guys, and it's garbage. Oh, Bryan Kohberger probably had been with Bethany. Oh my God. Oh my God. Please, Lord, I can't. So now that's the new rumor going around, that Bryan Kohberger had been out with Bethany. And because Bethany hasn't given a statement that we know of or that we've seen, they are saying that they need this defense witness, the prosecution witness, because they're going to prove that Bryan Kohberger wasn't there when the murders happened. And the only one that we haven't really heard anything about is Bethany. So guess what? He was out with Bethany. Hang on. Oh my gosh, I'm sorry. Corroborating evidence. So here it is. Where did they think they're going to get this information from that says Bryan Kohberger wasn't there? They say it right here. They believe that they may come from cross-examination of state witnesses, corroborating evidence from presentation of defense experts. Experts. It's going to be people that are experts in DNA, experts that are in GPS tracking, experts in phone data, experts in this, experts in Facebook and this. Those are experts. Dylan and Bethany are not experts. They are saying that Mr. Kohberger was out driving alone. Corroborating evidence may come from cross-examination of the state's witnesses. Corroborating evidence may come from the presentation of defense experts. So, I don't know. Are they going to have an expert that's going to say different than the state's experts? And if you have and now that you said this, corroborating evidence may come from presentation of defense experts. Now, there's another one that the prosecution is going to come after. We want who's your defense experts? You got to disclose that. Mr. Kohberger is aware of and will comply with his continuing duty to disclose information. He's aware of it and will comply. You're not complying because the state says, give us the alibi. The court ordered you to give the alibi. The prosecution had to come back a second time and ask the judge to compel you now. He's not complying with his duty to disclose information at all. Now he's even bringing in a defense expert, which he hasn't disclosed till now. They're just sinking their boat here as far as I'm concerned. The court may exempt Mr. Kohberger from further inquiry. So what look at this. They now want the judge to make some kind of order saying, you got to stop coming after Mr. Kohberger for certain things. Stop inquiring from Mr. Kohberger. He's chosen to remain silent. Well, if he's chosen to remain silent, then he shouldn't have said what he said. You shouldn't have said it on his behalf. Right? If you're going to claim alibi, you best present it and disclose it. This is all happening because of what you said and repeated from Kohberger. I'm going to be exonerated. I've got an alibi. I got defense experts. Now you've got to produce it. You said it. Now you've got to produce it. Especially once the state asks for it. Once the judge orders it. This is a typo. I'm joking. She said that. Is aware and will comply with his continued duty to disclose. He hasn't been. And now they want the judge to order, stop inquiring. The court may exempt Mr. Kohberger from further inquiry. Mr. Kohberger requests such an exemption at this time. Continued inquiry at this juncture delves into his case investigation as well as protected work product. An alibi is not work product. Work product is something totally different. Work product could be, oh my gosh, I'm going blank here now, but, and it's the same as with on the prosecution side, searching internet sites and this and that, where you're looking up certain things. What time is Chick-fil-A open to? I talked to the manager of Chick-fil-A and asked him if they were open at a certain time. That's work product. Has nothing. There's no evidentiary stuff there. It's just something they did just to check it out. You know what I mean? We went to robotics to see if they had video coverage. They don't have any video cameras. That's work product because there's nothing discoverable about anything that they found out there. They just went to see if possibly there wasn't, so it has nothing to do with the case. They can't use them. Work product is stuff like that has no discoverable information or dealings. So, in support of an exemption, Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court. So he wants an ex parte. They want for the exemption to meet, the defense and the judge maybe meet alone. An ex parte order is they don't want the prosecution there, and they'll explain why they want this exemption, but they don't want to give it to the prosecution. They don't want the prosecution knowing what they have to support this exemption. And that's that. So that's what we got with the Bryan Kohberger case, you guys. There's something else that I want to show you guys too. So let me stop sharing that. So to me, it's just a lot more carfunkel going on there to delay or to hinder the prosecution being able to get the strongest case together as they can, because they're constantly in court fighting these motions. Bottom line is he has to produce the alibi. If he doesn't produce the alibi, I do believe that this is what I think is going to happen. And this is only my opinion. The judge is going to deny throwing out the grand jury indictment. He's going to deny that. It's going to stand as it is. You want the grand jury indictment thrown out. You got all the paperwork. No, it's going to stand. I don't think he's going to throw that out. You're not going to get your preliminary hearing. And I think you're going to be ordered to turn over your defense information. Alibi information, sorry. Alibi information. If you don't do it, he may give them another 10 days maybe to produce it. And if not, that's it. Your alibi's gone. You can't use it. So, I mean, you can't claim you want a speedy trial. You can't claim and then do everything to get more time there. You can't say you want to remain silent and then come out with, I'm going to be exonerated and I've got an alibi. You can't do it. You can't have it both ways. You can't pick and choose which laws, should be applied to you. The laws are there for a reason and they apply to both across the board equally. So it's like, I don't know what they're trying to pull here, but it's not looking good on them. And I think taking the shots that they did at the prosecution is going to really irritate the judge. And I think the best that could come of this for Bryan Kohberger is that they may give him a little bit more of an extension. But I don't know. I don't know. We'll have to see what happens. His next court appearance is on the 18th, where this is all going to be, again, discussed. I don't know if we're going to be able to see it or not. Probably not. We may have people in the courtroom that we can get the information from. I don't know what's going to happen there. I know different news outlets have filed paperwork to have cameras in the courtroom, and right now it's walking a fine line. So I don't know what's going to happen with that. If we are able to stream it, I will. If I'm going to be able to get information that comes out of the courtroom, if it's not streamed, if I can get that, then I will cover that. But we'll have to wait and see. Now, I did put a community post, I think it was yesterday, that they have started the extradition. Before we get to that, here, I'm going to show you guys this again. So any of my lives from this Monday, the 31st of July, until Saturday morning when we go live, any of my lives, if you've given a $10 or more super chat, I've entered your name into a wheel where you are going to be able to possibly win this. You could, if you are catching the replay crew, oh my God, I missed it. Now I can't enter. Yes, you still can. On any of my lives, and make sure, please, from July 31st until Saturday morning, any of my lives this week that I have done, and you're watching the replay, you can hit that little heart. It's down here somewhere, just below the video. You may have to click on the little 3 dots that are down here. And you can donate $10 that way too. Your name, I will see it. Your name is going to be put on the wheel. So this is it. This is the rose quartz set. This is the necklace, the pendulum, and the bracelet. So this, as well as whatever else I decide to throw in with this, that is going to be the draw this Saturday. I think I usually do them at 11 a.m. It's either 11 or 11:30 a.m. Watch for that. I'll probably put it up on Friday. And then I'll have my lives again Sunday. And then I will have something new for next week. So has anyone else noticed more fired up Willow gets the more prominent her Canadian accent? I got an accent. Becomes I'm waiting for her to break out speaking fluent in French. What goes she in coin là? Not English at any second can wait. Speaking in tongues. Speaking in the tongues. So, yeah, I get fired up, and yeah, sometimes the English gets mixed with the French, and I gotta really watch what I'm reading on screen, because we say things sometimes differently here. And I'm not saying pronunciation of words differently here than in the U.S., especially the Deep South. I love the Deep Southern accent. Don't you know? Eh? What are you talking about, eh? I love her in general. I love you guys too. And on a note, can you imagine being one of her children trying to play and talk your way out of this, and they got caught? Oh, my kids hated it, you guys. I'm telling you, they hated it. Hated it. They didn't get away with too much. And being that I have abilities and I'm very intuitive too, yeah, they didn't like it. I gave them a break. I chose it. I picked my battles. So I really did. So with the Lori Vallow, okay, so let's get rid of this one. We're done with that one. Let's bring this up, I think. Okay, so if you didn't see it, let me share my screen here. Entire screen. This one. Share. There's no audio, so I don't got to share the audio. Here we go. Whoops. Why is this not coming up? Stop. There we go. Okay, so for those of you who have not seen this, I posted this, I think, yesterday. This is Lori Vallow, Maricopa County. First degree premeditated murder. This is regarding Charles. Here's the warrant for her arrest, and they have filed for extradition. They're extraditing her to Arizona. And this is for first degree premeditated murder. We don't have any of the information on it yet. This is all we've got until they go and pick her up. Then they will start a file on her, and I will be able to see what is in that, and I will bring it to you. The next one that we got is this one here from the Maricopa County Attorney, Trina Kay, Superior Court of the State of Arizona, in and for the County of Maricopa. Count 1, conspiracy to commit first-degree murder, a Class A1 felony dangerous. The grand jurors of Maricopa County, Arizona, accused Lori N. Vallow on February 24, 2022, charging that in Maricopa County, Arizona, Lori, on or about October 2nd, 2019, with the intent to promote or aid the commission of an offense, to wit, Lori N. Vallow agreed with Alexander Cox that at least one of them or the other would engage in conduct constituting the offense of first premeditated murder in violation of ARS, blah, blah, blah. The state further alleges that the offense charged in this court is a dangerous felony because the offense involved the discharge, use, or threatening exhibition of a gun, a deadly weapon, or dangerous instrument, and or the intentional or knowing infliction of serious physical injury upon Brandon Bordeaux. So she's also being charged with the attempted murder on Brandon Bordeaux. So she's going to be charged with the Charles Vallow and Brandon Bordeaux. So there's not a lot that is this can back a true bill. We're not going to get this. This is the county attorney. We will not get to see this or this signature because that is kept secret. This would be the foreperson of the grand jury. So this is all that we have right now. Once they extradite her, let me just get over here. Once they extradite her and get her back to Arizona, then they will start a file on her, and then we will be able to see everything that's going on and what they have. We're not going to see the grand jury stuff, but we will see a probable cause affidavit on both for Charles and for Brandon Bordeaux. Marie Burke says, Lori was holding her graduation certificate from the jail to the big house. That was her being booked in at the prison in Idaho. And it starts with a P. I can't pronounce the name, so I'm not even going to try. But it starts with a P, and it's the woman's maximum security facility in Idaho. But we do now have the extradition. The extradition is in progress. So the warrants are already been filed and served, and now they are going to extradite her, which means because she is a felon, she's already been convicted. She is serving time right now for murders and conspiracy to commit murder. She won't go to, I don't think she will go to a jail. I think she will be held in a prison in Arizona. Don't quote me, but that's what they do here in Canada. So if you're already serving time for a felony, especially murder charges, and you're extradited to another province for other charges, they hold you in federal prison. They don't send you back to the circus, which is like the little county jails and stuff like that. They keep you housed in a federal prison. Yeah, Tammy, her best friend. Oh my gosh, I was so mad. Thank you, Shy, for staying on top of that. Mary Michael says, I get beat up all the time for my South Jersey. I love your guys' accents. Red gum. Pocatail for Idaho prison. Pocatail. Pocatail? Pocataila. 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 That sounds like it could be it. Pocataila. Or is it Pocataili? Because A-E, is it a long A or a short E? A. Pocataila. I think it's Pocataila. Thank you, Nana. And Nana, your stuff is going to be shipped out to you. So whoever the last draw, I know Sunday, you guys, I didn't do the mini reads because internet was out. I'm changing my internet provider. So I'm going to go with the high fiber optics that are underground. I'm done with this above ground stuff. Pocatello, Women's Correctional Center. Pocatello. Poke. That's it. What Shivani said right there. This one. Tello. Pocantello. Huh? I don't know. It's that. That's where she is right now, and she's being extradited from there to Arizona, and I do believe that she will be held in a federal prison. So let me just see this. What was this? Somebody sent me this. So Mr. Kohberger has had a long habit of going for drives alone. Often he would go for drives at night. His defense attorney, Ann Taylor, wrote in the document he did so late on November 12th and into November 13th. So she's putting him out there like, ugh. Kohberger isn't claiming to be in any specific location at any specific time, according to the document, and may have witnesses who can corroborate that he wasn't at the home where the students were killed. His defense team is still going over transcripts of grand jury testimony and other evidence from the investigation, his attorneys wrote. So it is too soon to detail exactly who those witnesses might be and what they might be able to testify about. The defense has stated, all that can be firmly stated at this time has been stated. Idaho law requires that defendants notify the prosecution if they intend to present an alibi defense, which is generally a claim that they were somewhere other than the crime scene and have witnesses who will verify that. Let me see if there's anything else in here that... And it says the court document filed Wednesday is the first time Kohberger has said anything about his whereabouts on the night of the stabbings. He didn't say where he was. This says the court document filed Wednesday is the first time Kohberger has said anything about his whereabouts on the night of the... Yeah, well, see, the way I read that is that he actually said where he was. It's the first time he said anything about his whereabouts. Well, he didn't. He said, we can't tell you that right now. We can't be specific on that right now. His defense team submitted it after prosecutors asked the court to force Kohberger to reveal if he intends to offer an alibi. And he has to. And I think the judge is going to do that. Oh, here we go. Here we go. Let's play with words. Yes, he did. He said he wasn't there. Okay, I'm going to read it again. The court document filed Wednesday is the first time Kohberger has said anything about his whereabouts on the night of the stabbing. The first time he said anything about his whereabouts. That is saying, I'm going to tell you where I was, the whereabouts. Just saying he wasn't there is not, it's not submittable. He can't just say, I wasn't there. And the way this is written, Kohberger has said anything about his whereabouts. So that's like, okay, well, I wasn't there because I was out driving around in North Idaho. I wasn't in South Idaho. I was in North Idaho. That would be saying something about his whereabouts. Simply saying he wasn't there is not saying something about his whereabouts. Playing with words. It's like, don't get me going, Carla. I love you. I start laughing. I start choking up. All while practicing his potato sack racing skills, and then dropped the hot potato and had to go back to get it. And I do believe that he went back to he did go back the next morning around between 9 and 9:30. Didn't stay long. And I think he went back and he was like shocked that the place wasn't crawling with cops. So I believe that he did go back up behind to see if he maybe dropped it while he was getting back in his car. Mary Michael. Don't mess with her when she's filing front. The thing is, I get fired up because I hate stupidity. I hate when people play with words. I hate when people play with the law. You know what I mean? I despise it. Despise it. So yeah, I get fired up when people are playing with, and his lawyers know what they're doing. They're playing, and they know they're playing. Yeah, it is. It's nerve-wracking on all of us. I agree, my dear. Potty dance. Oh. He has exercised his right to remain silent unless it benefits him. I'm going to be exonerated. I have an alibi. That's not remaining silent. I'm just reading through this to see if there's anything else. That's all I can give you at this time. Like, we'll see what happens. Maybe I'll pull a rabbit out of a hat and surprise us all, and we'll have rabbits too. I don't know what they're planning on doing, but they can't do it. They can't just spring something on the prosecution like that, especially once they've already said they have an alibi. Or he said to them, who repeated it to the court. Because I get jumped on a lot. Bryan didn't say that. Okay. You're right. Bryan didn't stand up in court and say, Your Honor, I have an alibi. What happened was Bryan told it to his attorney, and his attorney stood up in court and said Bryan has an alibi. Like, stop mincing and playing with words and blah blah blah. It is what it is, and people tend to do that a lot when they want to distract from the actual evidence. Like, you can have whatever opinion you want. If you think he's innocent, get at her, get at her. But they've shown nothing where he's innocent yet. Nothing. Like, and I'm not saying the defense has to show anything. I'm saying in the paperwork, yes, it's a lot of circumstantial evidence, but everything points to him. Even when he's tried to come out with certain things, it still points right back to him. Rabbit stew and potatoes. Ugh. No. Let's see what else. Let's see what I usually don't do this, and I'm not used to this X. Okay, what's this? Okay, so I just got sent something here this morning. Office of the District Attorney, County of Suffolk. They're going to be having, I guess it should be going on anytime if it hasn't already, a media advisory regarding the Gilgio Beach homicide stuff. They got more. They have August 4th at 10:30 a.m. their time. So 10, 11, 12, 1. So that's going to be happening. Do you guys want me to go and see that? Do you have a link? Matt, do you have a link? Let me see. Hang on. Oh, did he send me a link here? Hang on. No. So what I did find after I was, that's another terrible one. Police investigating the Gigolo Beach murders announced they have identified the victim, previously known as Jane Doe number 7, as 34-year-old Karen Vergata. Law enforcement believes she disappeared around February 14th, 1996. So, I haven't really been following that one, you guys, with being sick and all, and still going through what I'm going through. And I mean, it's getting better. I am a lot better. I'm like probably at about 80% now. I need to get up to at least 90. I'm still having problems with this digestion, but that could be the pills they got me on. But anyway, I've been trying to follow it the best I can. Let me see if there's anything going on with this. Office of the District Attorney, County of Suffolk. Okay, let me see. Let me see. Oh, she was such a cute little kid. Here, I'll show you quickly. I can only show you quickly. So be on your toes. I can only show this quickly. I don't want to. I'm going to put it on screen 2 seconds and then take it off. This is her. That's her. That's Karen, the one that was missing since 1996, Valentine's Day. Okay, here it is. Hang on. I don't know if I'm going to get hit for this. I don't know if I can show this without getting a friggin' strike. I think I can. I think I can. Okay, let's show it. Oh, wait. How about you guys, I put a link to it. I'm not going to show it. I'm not going to take the chance of of getting copy. So there it is if you want to go and see it. They're talking about... Okay, hang on a sec, you guys. Okay, give me just a second here. Okay, you guys, so that's what the press conference is with what I just read you. The legs and feet of Karen Vergata, 34, were discovered on Fire Island in 1996. More of her bones were also found. Investigators in the Long Island serial killer case revealed the identity of Jane Doe number 7. So I'm assuming that the rest of her was found there. So they're probably going to link that to, what's his name? Rex Horaman. I don't know how to pronounce his name. So that's what I do believe that is all about. Let's see what else is here. So breaking news, a cyber attack this is an hour ago, you guys. A cyber attack has disrupted multiple hospitals and healthcare in several U.S. states, causing emergency rooms to be closed down and ambulances diverted. So there was a cyber attack on the hospitals. That's pretty bad. Like, you got to be low of the low to attack a hospital. There was something that Kay Woodcock said, you guys, regarding Lori Vallow. A statement that she made, I'm going to say it to you guys instead of showing it. She said something and I just burst out laughing. Kay Woodcock, having lunch with our dear friend and catching up with her about inmate 153745, it dawned on me that she didn't even make the cut. She's not in the 144,000 that she was trying to save. Missed it by 13,745. Praise Jesus. Because her inmate number is 153,745. She didn't make the cut of 144,000. I thought that was funny. So apparently, with this Rex Horoman, they can't run his DNA in CODIS because he's not a convicted felon or sex offender in New York. So apparently they can't use that system. So somebody asked, so how are you going to try and link him? The DA said that he said they have other ways of linking him via DNA. See, there's a lot of people commenting. I'm seeing this now with this. Everybody's now finding this new document that came out with Bryan Kohberger. And this one person said, Ann Taylor just embarrassed herself by presenting to the court the most ridiculous Bryan Kohberger alibi possible that now makes Bryan Kohberger look even more guilty than he already is. She admits Bryan Kohberger was driving around alone at night during the early mornings of November 13th in the area of the murders. Ineffective assistance of counsel, Kohberger should can her, give her the boot. A lot of people are commenting on it. And somebody else says that's just her attempt to try and explain away all the pings and video. He's just driving around and it's normal for him. But she is compelled to provide something that is relevant, and she's not. Not too many people are buying it. I'm just looking for anything else I can let you guys know so I don't have to throw it into a community post. Oh, poor panda. Oh, sorry. I'm scrolling here and I just see a poor panda fall down the side of his enclosure and now he's rolling down the hill. Oh, poor little guy. Oh, hacking and coughing here, you guys. Yeah, this is just basically full of all the Rex Hummerman or whatever his name is about identifying others. Oh, this damn mistake. We got another tornado. 2 more tornadoes touched down again, you guys, just north of me, about 15 miles north of me. So last night we were under tornado warnings again. Yeah, so that's about it that I see right now, you guys. I'm going to... Sorry, I got a coughing fit coming on here. I'm going to keep an eye on the court papers over on the court site because I'm expecting... I've heard about it. It's only rumor. So I'm going to wait till I see the court documents myself. Yeah, I seen those pictures. They cut open his back. Like, I feel bad for his wife because that house was turned upside down and they cut a hole. It looked like a nice bathtub too. It's like it's almost like how a clawfoot sits there by itself and they built, but it's not a clawfoot tub. It looks like it's an acrylic one to me. But anyway, nice bathtub with like, they built like boards around it. And they cut right through that. They cut right through that. Alley Cat says how the fires that were near me are all gone. All the Quebec fires, except for one. There's a small one, but it's contained. All the other ones that were out of control, they're all out. So, and that one that is way up north in northern Quebec, that's not affecting us down here at all. It's just a small one and they've got it contained. So now out west in British Columbia and Alberta and stuff, not so good. Let's see what they're saying here. Yeah, people are saying, well, they had all the pings where his car was by the cameras that picked him up, so they had to admit to something. And that was their way of maybe explaining before trial why his car was seen on all these CCTV cameras. That Bryan Kohberger case. And he just admitted he acted alone. I caught that too. He was alone. And he admitted that. His lawyer just admitted it in the court documents she just filed. He was alone. So was anybody else arrested? Maybe remember when he made that comment? Oh, did they arrest anybody else? Well, that's his legal background kicking in, right? Why he said that. I seen right through it. But that just blew that right out of the water because his lawyers just admitted that he was alone. And I say, she threw him under the bus. Like he said, I'm going to be exonerated. And did they arrest anybody else? But his lawyer just said he was alone. And I'm anxious to see the pictures of who he has on his phone and stuff like that. So, like I said, there's a lot of evidence that they got, circumstantial evidence that they got, that all points to him. They got him in that area. Like, tell us why 13 times, the 13th time, obviously, he committed the crime. But the 12 times, why were you in that area? Who do you know that constantly kept bringing you back in the late and early hours of the morning to that area? Why? You live in Washington. You can't drive around over there in Washington. Why did you come to Idaho? That specific area. Like I said, there's no Walmart, there's no corner store, there's no Chick-fil-A or whatever that is, that store you guys got. There's nothing there that you can say, oh, well, that's the closest Chick-fil-A, so that's where I go. No, there's nothing there. It's all residential. There would be no reason for anybody to be in that area. And the way it's all dead ends there, unless you know somebody there and going to visit somebody there, you wouldn't be there. Especially 12 times and all late at night into the early morning hours. That's stalking. That's peeping Toms do that. Better say nothing than to make unprovable excuses. Right. But they have now said that he was alone that night. So now if he tries to say, well, I didn't do it, this buddy I met up with, he's the one that did it, that no, just backfired on him. Sorry, you guys, for the cough. It's some medication. It's like I had the starting of pneumonia. So good thing that I did go and see my doctor, but I've been on these pills for a few days now, and they are horrible on your stomach, on your guts, but it's clearing everything out now. So I go through these coughing fits. He was getting his taters. Yeah, that's why the defenders now are pulling the Bethany card to offer excuses to why he was in the area often. Yeah. And because Bethany really hasn't, we really haven't heard a statement from Bethany. We've heard via the probable cause affidavit some of what Dylan has said. We've heard absolutely zero from Bethany. But yeah, that's the new rumor going around, that he was with Bethany. Had to have been. And oh my gosh, it's just like, what's this one? Somebody's looking. Wow, Fox really has a turnover with their reporters. I'm telling you that. Yeah, so there's a new thing out in Canada now that we are not going to be able to look up any news online on Meta. It's being blocked. So if I wanted to go on and look up my local news online, I can't. I'm blocked. It's bad enough I'm blocked from most of the stuff in the States and other places abroad. I'm being blocked in my own country now from looking up news articles or watching news online. It's crazy. Some of these things are on here. Well, I guess I can show you this one. Remember I told you here, share screen. Window, this one. Yeah, see, this is from the tornadoes that touched down. Ottawa Fire Services reports part of a roof has been ripped off in Riverside South in the 4,000 blocks of Canyon. Oh, firefighters arrived and confirmed part of the roof was, in fact, ripped off. All occupants. That's part of the tornadoes that hit last night. This was 18 hours ago. This is last night. They started coming through around 4 o'clock in the afternoon. So it's like it's been nonstop here, you guys. Up in the Ottawa Valley, right into the border of Quebec and down into southern Quebec. They've been getting bombed too, as well as us here up in the Ottawa area. Like to have one tornado warning, we've had probably 4 or 5 in the last 2 weeks. Yeah, so I'm not seeing much else regarding the Kohberger stuff, you guys. It's a lot about what we just discussed. But a lot of people seem to be, I mean, I've seen some here that are still hell-bent on saying he's innocent. But from what I'm seeing right now, people are saying that his lawyer just threw him under the bus. So this is from News Nation, and Brian Enton says, in a new filing, Bryan Kohberger's attorneys say he was out driving at the time of the Idaho quadruple murders, but there's no specific witnesses to confirm his alibi right now. So it's like, yeah, because you got none. You're yeah, they're saying that Court TV is saying Bryan Kohberger, who's accused of fatally stabbing 4 University Idaho students, says he was on a solo drive at the time of the deaths. So I kind of read that right. It's like, yeah. Well, now you just admitted that you did this alone. Yeah, a lot of this I can't share. That's how I got my strike the last time, you guys, when I showed that little snippet. So I can't show it, but yeah. I put the link there if you want to go over and read up on that. Let's get rid of that. Let's get rid of this. So we're going to wrap it up, you guys. Again, if you do want to be, I'll show it one more time here. If you do want to be entered, the draw is this Saturday morning. I believe it's 11 or 11:30. I do the draws. This is the rose gold set. Here is the necklace on a gold tone chain, the pendulum, and the bracelet, also gold tone. And this is the rose crystal quartz. So that, plus I throw in a couple other little things with it. Any donation, super chat of $10 or more, you get your name on the wheel. And Saturday, I will be putting everybody's name on the wheel. So make sure you're there. Watch for that. I will put the thumbnail up on Friday, so you can hit the notification bell. I'll put everybody's name on the wheel, and then we will do the draw and see who wins this one. And everything from the last couple of weeks, you guys, that has been won, whether it's been through the last week's draw for the Tiger's Eye set, and the Sundays that I give, if you get a mini read, you also get something, a draw to get in for whatever it is I'm giving away that day. Those are all going out on Monday. So this will be mailed out on Monday also. That's when I'm going to have the draw on Saturday. And I do that, you guys, because I'm shipping from Canada. So I'm going to ship everything out like every 2 weeks. So there'll be 2 of the weekly draws and then 2 of the Sunday draws that will be shipped out every 2 weeks. So this one, the Tiger's Eye, and the one from 2 weeks ago draw are all going to be shipped out on Monday. And this Sunday's, whoever wins this Sunday, I've already got it here for this Sunday's draw. If you get a mini read, your name will be entered into the draw. This is another St. Michael's necklace. And I've also got here, let me just open this. I'm also going to send out, this is an opalite. So you'll get one of these. And I've written down on here what it is for. So that's, if you get a mini read, you're automatically entered into the draw for this on Sunday. This is this coming Sunday. We will be drawing from everybody who gets a mini read. This is what the prize is this week that I give, just to give some thanks back. And this week's draw for the week is going to be this set. You're going to probably get about $100 worth of product. So yes, the mini reads are $20 on Sundays if you want a mini read. So you get your live mini read and you get your name entered into the draw for that. I draw that Sunday right after the mini reads are all done. I draw for this to see who is going to get that. Saturday, this is from Monday, this Monday that just passed, till Saturday. You can enter any of my videos from this week. If you've missed and you're the replay crew, down here, there's a little heart. You may have to click the 3 little dots that are way over here. You can enter that way too by putting a $10 super thanks. So all my videos this week, I will go through all the comments and see who's put in super thanks there. I do know some have sent over $10 through PayPal too. If you want to use PayPal, you can do it that way too. I will check that come the end of the week to see who's entered there through PayPal. And you can enter right up until the time of the draw on Saturday morning. So with that being said, you guys, we are going to wrap this up. I want to thank you guys for spending the last couple hours with me going over this new filing that the defense filed regarding alibi. I think it's just smoke and mirrors. Delay, distract. I think the judge is finally going to have enough. And I do believe that they are pushing their luck with asking for another continuance. You've already had one of 37 days. I don't think the judge is going to offer anything more than that, they're going to have to produce that alibi, or the judge is going to take away their right for alibi. So he'll probably give them a few days to get their crap together and command them. Now, he's already ordered it once. So now he's going to tell them, if you have an alibi, you are claiming alibi, there are rules how you have to disclose it. If you cannot follow those rules, then I'm going to take away your right to alibi. So with that being said, let's see what happens. His next court date is on August 18th. If we can live stream it, I will bring that to you guys. If not, I'm sure there will be somebody in the courtroom that I can get information and just repeat it to you. So with that being said, thank you so much, you guys. And I'm going to close it out like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. See you again in the next one. Bye-bye for now.